as well? The information we have in the committee meeting room from IT personnel is that the video is running. Okay, I think we have then, if it wasn't running before, we have now corrected it and it is up and running. Is that where we are now? Okay, it looks like it is up and running, and if not, I'm sure I'll receive some texts about it and to keep an eye on that. So thank you for your patience for those following online. Thank you, Senator, for your patience in allowing me to stop for
That's
a minute.
fine. As you were going through all that, I looked at page 6 and I see that it's alternating chair and vice chair. It's normal procedure. So I got the answer to my question. I just missed that when I read it earlier. Thank you, Madam Chair.
Thank you, Senator. Mr. Thompson, if you'll continue.
Very good. Thank you, Madam Chair. This is Jason Thompson again, continuing. Section 2 then, that we were just getting into, great segue, is on pages 5 through 7. That does create the Joint Committee on Emergency Management. It would consist of 5 members of the Senate and 5 members of the House, specified there in the bill. Each congressional district in the state should be represented on the Joint Committee by at least one member who's a resident of that district, to the greatest extent possible. And I'll give you the caveat. We only added that language because in the unlikely event that all of the members of leadership are from the same congressional district, there are only 2 other appointees outside of leadership. And so there's a very remote chance that only 3 congressional districts could be represented. And so we had to stick in the possibility that 4 could not be represented, just to not create any legal issues. So that is why that is there. The intent is that 3 or 4, all 4 would be represented from across the state. The Joint Committee essentially just performs the functions that I'll talk about during other sections in the bill, primarily with regard to Section 1, where they would review executive orders issued by the governor. They would also receive applications to extend those public health disaster emergency declarations when the legislature is not in session or when in session and adjourned for more than 3 days, as we discussed. So primarily their duties are prescribed by statute, but the LCC could provide other duties to this committee, as could the legislature by other enactments. They would also have the authority to require reports and testimony from the governor or the governor's designee, the adjutant general, the State Board of Education, the Secretary of Health and Environment, and any other state or local official with information relevant to emergency management or the powers and duties of the committee. So they would be able to ask for reports and testimony from all the folks we're talking about in this bill, essentially, and maybe even a few more if it was relevant to their duties. Moving then to Section 3, which...
Just a moment, if I might, Jason. I had a quick question regarding Section 2 and Section 1. Section 1 on page 4 at line 11 requires the governor, after submitting the proposed order to the Attorney General, to then submit the order to the Joint Committee. Is that so even if the legislature is in session?
Madam Chair, Jason Thompson again. Yes, that is correct. So even when the legislature is in session, the Joint Committee is the one reviewing the executive orders. The caveat is that the legislature is allowed by concurrent resolution to terminate any executive order. So the legislature can act on these when in session, but the Joint Committee would be authorized to meet even during session to review executive orders.
And therefore, the Joint Committee, even when the legislature is in session, also has the authority to approve or not approve an executive order. Is that correct?
Madam Chair, that's correct. They are the body tasked with the executive orders. The legislature, of course, does have that override that I mentioned for any executive order, but they would not be, there wasn't a mechanism created to refer an executive order to the legislature. It was just to refer it to the Joint Committee, regardless of when it happens, whether the legislature is in session or not.
Thank you. We have, that brings up a question from Senator Corson.
Thank you, Madam Chair. Since we're right in that section, I wanted to this feels like the appropriate time to ask it. I just wanted to confirm, Mr. Thompson, that I'm correctly understanding that the Attorney General provides an opinion to the governor, but that opinion in and of itself doesn't have any authority, as far as it doesn't have any effect on the order. It's then, it would be actually the joint committee that would be able to, perhaps based on the Attorney General's opinion, make a decision whether to approve or not approve. Am I correct that just in and of itself, the Attorney General opinion does not cause or not cause anything to happen?
Mr. Thompson?
Thank you, Madam Chair. Jason Thompson again. Senator Corson is correct. The Attorney General is just tasked with reviewing and issuing an opinion. That opinion is published and attached to the order, but there is no authority to reject or nullify the order, only to issue the opinion. That all rests with the joint committee, and they may, of course, accept or reject the opinion of the Attorney General at their discretion.
Thank you. Senator Pyle had a question, then I'm sorry, I think I skipped Senator Thompson earlier. Go ahead.
Thank you, Madam Chair. My questions concerning Section 2 be page 7, lines 3 through 4. And it says, in addition to other powers and duties authorized or prescribed by law or by the Legislative Coordinating Council. Are we presuming here to delegate authority to the LCC to write law? I mean, I'm just wanting clarification on this, because the way it reads, it sounds that way, Jason.
Mr. Thompson, if you can answer.
Thank you, Madam Chair. Jason Thompson again. Madam Chair, this provision is similar to other joint committees and essentially just allows the LCC to delegate a duty to the joint committee. Just for example, an emergency management issue comes up during session. Chairperson Warren decides to ask the LCC to refer that issue for an interim, and the LCC decides the most appropriate committee to hear that issue would be the Joint Committee on Emergency Management. So they refer that issue to them, and they would be authorized to hear that issue. The beginning of that clause, the powers and duties authorized or prescribed by law, is to encompass the powers in Section 1, and then the later powers discussed in 48.925. But also any other duties I may have missed outside of those two sections. But the powers and duties would have to be prescribed by the LCC, sort of in accordance with the LCC's lawful authority to do that. I don't know that they could create a statutory power or duty, but they can refer issues or ask this committee to do something. But I don't think it broadens the LCC's authority beyond what is already there.
If I may, so I'm just so I have clarity on this. So the LCC would actually have some jurisdiction over the emergency committee, joint committee?
Mr. Thompson?
Thank you again, Madam Chair. Jason Thompson. Yes, the LCC has authority over all committees of the legislature. That's my general answer. The authority over this committee is a tiny bit different, because it's a special kind of joint committee. We only have a few like this that can meet during session, that can handle business during session, and they also have specific statutory duties outside of session in place of the legislature almost. And so, for example, this committee would not have to have its meeting days approved by the LCC. However, to get paid for attendance, they would have to submit vouchers to get paid by the LCC from the appropriate funds. So there is the usual LCC authority over this committee as over all committees, but a little less than normal because of the need to call this committee so quickly, maybe not get approval of the meeting days by the LCC, and some of the other things that most joint committees have to do. So it's walking that fine line of, yes, they're under their authority, but they have a few options that other joint committees do not.
Thank you very much. Thank you, Madam Chair.
Thank you. Senator Thompson?
Yeah, one quick question way back on page 2, line 9, at the end of line 9 there. talking about the disaster emergency may be extended for specified periods not to exceed 30 days each. If we struck that word each, then would the new, say, would, after 30 days, the joint committee or the governor would have to declare a new emergency, correct?
Mr. Thompson?
Thank you, Madam Chair. Jason Thompson again. Yes, to Senator Thompson's question, the way it's set up in on page 2 right now, once the 15-day time limit has run, so the proclamation is issued, it can last for 15 days unless ratified by concurrent resolution of the legislature. And that can extend it for any amount of time that the legislature deems necessary. And that can occur at any time, of course, that the legislature is in session. But if the legislature is not in session or is adjourned for more than 3 days, that's when this provision kicks in that you're referring to on page 2, beginning in line 4 through line 9. And yes, they would, by affirmative vote, be able to extend the emergency for 30 days, and they would be able to do that multiple times because of the word each. So after 30 days or before the 30 days runs out, the governor could submit a new request to the committee to extend it, and they would then approve or deny. And that can continue for as long as the legislature is not in session or adjourned for more than 3 days during session. I would caveat that unlike the current disaster emergency statute that doesn't have explicit restrictions on emergencies from the same or similar disasters, this section 1 has an explicit prohibition on the same or similar disaster being declared again under a new declaration. So the push and pull here, I think, not to be the policy person, but I think what I was told in drafting this is that in order to have the restriction on not issuing the same or similar disaster emergency more than once, the opportunity to extend the same disaster emergency more than once for limited periods of time was the push and pull that was given there. And of course, as a policy decision, you could strike the word each. They would get one extension, and then it would fall, of course, to the legislature that would have to extend that by concurrent resolution. That would be the only option provided in statute. And if it was the same disaster, the governor could not issue a new one on that same issue. And so it would fall to the governor and the legislature to work that out, I suppose.
And just one follow-up, Madam Chair, for Mr. Thompson. So the way I read this then, with the 15 days, and on day 15, the Joint Committee could extend it 30 days. So you're right there, you got 45 days, correct? Or does that 15 days and 30 days run concurrently or consecutively?
Mr. Thompson?
Thank you, Madam Chair. Jason Thompson again. I believe it would be consecutive, just like under the current law, not concurrent. So, for example, the declaration is issued, the 15 days expire. You say it's issued on the 1st of the month, it expires on the 15th or 16th of the month. Let's just say the 15th because that's easier. And so the new extension would say that is extended from January 15th when the other would end until 30 days later. And so I think it would be a concurrent period that would be a total of 45 days.
Okay. Thank you. Thank you, Madam Chair.
Any other questions before we move? I think we were on getting ready for section 4, I think. Thank you, Mr. Thompson. Go ahead.
All right. Thank you again, Madam Chair. Jason Thompson again. We're actually only ready for section 3. Imagine that. But I'm glad we've taken the question so far on 1 and 2. There's a lot of the policy in this bill in those first sections, and that's why I appreciate those questions and glad we got that cleared up. Section 3 shifts to the other major policy issue presented in the bill, and that is cities and city health officers and the restrictions and procedures when they are issuing orders to prevent the spread of an infectious, contagious, or communicable disease. City health officer orders are reviewed, amended, or revoked by the governing body of the city. That's a mandatory requirement under this section. Persons aggrieved by an order of a governing body can then request a hearing that has to occur within 72 hours by that governing body. And then if they're aggrieved by that decision of the governing body, they can request a hearing in a district court. So all of that is provided in Section 3. I won't go into too much more detail, and it's actually covered again in some Chapter 65 statutes near the end of the bill. But in Section 3 here, we introduced that concept with a new section to cover some things that aren't covered in Chapter 65 already. And I just mentioned requesting a hearing in a district court. That's the segue to Section 4, which is on pages 8 and 9 of the bill. This is the procedure for requesting a hearing in district court when a person is aggrieved by an order described in this bill. There's 4 different orders that can end up in the district court under this section. The first is issued by the governing body of a city or a city health officer, as described in Section 3. The second is an order issued by a board of county commissioners or a local health officer under 65-201 or 65-202, which are talked about later in the bill. The third is an action taken or an order issued by the Secretary of Health and Environment under KSA 65-101 subsection A5. That's also discussed later in the bill. And the final category is an action taken, an order issued, or a policy adopted by the Board of Education of a school district as described in the next section, Section 5. Now, all of these end up in the district court after an aggrieved person files a request for a hearing with the court, and all of them must be conducted within 72 hours after receipt of the request. However, the district court may extend this 72-hour deadline in extraordinary circumstances, is the word provided in the statute. I would note for the committee that this procedure and the 72-hour hearing in particular is drawn from current law in 65-129C. That's a statute that allows a 72-hour hearing for a person that's subject to quarantine or isolation. And given the sort of habeas nature, to steal the Latin phrase, the nature of that proceeding requires it to be conducted quickly. And so that procedure has been borrowed and applies to someone aggrieved by one of these orders to appeal to that governing body that issued that order, and also then appeal to the district court. And all of those have to happen in 72 hours each time, unless there are extraordinary circumstances that allow that to be waived by the governing body or the court. I think that's it for Section 4, unless anybody wants to stop there, because I can move on to then Section 5, where we get into the schools and the kind of orders or actions they've taken that would subject them to review that I just described. So I can pause here for a moment if you'd like, Madam Chair.
Thank you, Mr. Thompson. Any questions from the committee? Senator Pyle.
Thank you, Madam Chair. And Jason, I'm curious, throughout the bill, there's reference to accepted scientific means. What is that? What are those? Is there something we're referencing here that I'm not aware of?
Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. That is a term adapted from Chapter 65. Most of the orders that are issued by any of these health authorities require accepted scientific means. So we've carried over that concept into this bill as well. I believe that has a meaning within the public health sector, and then within the governing bodies that would have to deal with these issues, it may have a particular meaning to them. And so they would have to justify their decisions and say, these scientific, this scientific data that we've received, we believe is accepted and relevant. This other data we received, maybe we don't believe is accepted or relevant. So there is some room in there for consideration by the appropriate authority, but that does have some meaning in Chapter 65, is my understanding.
If I can just follow up, is there someone that sets the standard for that or defines it within the health community? And is there a way of, can we get an answer to that? Maybe not today, but tomorrow, as to where we're getting these accepted scientific measures? What's defining those? What board or who determines that is, I guess, what I'm trying to find out. So that's my question, and we may not have an answer today, but maybe we can get it tomorrow.
Exactly. Or it might be a policy question for the committee to debate and consider if Mr. Thompson doesn't have a statutory reference for us, but something to keep in mind as we craft and look for amendments if needed to the bill. Mr. Thompson, do you have an answer in statute for us already, or is this kind of more of a policy debate that we'll need to continue?
Thank you, Madam Chair. Jason Thompson again. I'm going to run the...
I think you accidentally muted yourself, Mr. Thompson.
I did. Thank you, Madam Chair. Switching screens because I wanted to run the search one more time just to see if there was a definition that I was forgetting. And I'm not finding one off the top of my head or through my quick search here. But my research, I recall from Chapter 65 is sort of what I was getting at, where it's up to, in large part, it's up to the person making the decision, whether the data they receive, the science they're reviewing and receiving is accepted in the scientific community as valid or not. And so it would be incumbent on that officer and then the body reviewing it to decide, was this accepted science or not? And even then to the court, they would have to look at whether it was accepted scientific data or not. So that's my non-answer answer. And as you said, there is a policy issue here in a way. If the committee were able to craft some sort of restrictions on what is accepted and what is not, I'd be happy to draft that. I certainly don't have any idea how I would do that right now. It seems like kind of a difficult issue for me, but there may be some way we could do that I just haven't thought of yet.
Thank you. Senator Thompson.
Yeah, just to piggyback on that conversation, would we be able to create a definition in this bill for that particular term that supersedes the Chapter 65 definition? Because a lot of concerns that I have, and I know that there are other senators outside of this committee have, is that the state health officers, these county health officers have followed the CDC guidance, whereas there has been plentiful additional information provided by other research doctors with peer-reviewed studies that were never considered. And so I think we've got to be very careful going forward that we don't narrow our scope so that it's a rubber stamp of whatever the CDC says. And that's how we've extended this emergency far beyond what anybody anticipated. So I don't know if we can put a specific definition in there for the use of this bill that would give us a little more reassurance that we're not at the mercy of the CDC or heaven knows, even the WHO, that we can consider other sources. And that would be my question or comment. Thanks, Madam Chair.
Thank you, Senator Thompson. Those are concerns and comments that I've heard expressed outside the committee meeting room too, and glad we're having that debate and continue to have that while we work through the bill, or actually as we hear it today. We're not working it yet, but as we discuss it. And looks like probably for the reviser, maybe an amendment might be coming to kind of narrow that down. I've heard from constituents, and I have my same concerns that we need to have some direction as we go through emergencies, that that ultimately the power and the authority rests with Kansans as to how we can get through this. Any other comments or questions about Section 4 before we move on? Seeing none then, for Section 5, Mr. Thompson.
All right, thank you again, Madam Chair. Jason Thompson again. So moving then to Section 5, which is the section about schools. I will note a couple things at the outset. This does provide a procedure. Sorry, scrolling past my note here. Does address the issue of actions by a Board of Education of a school district during a state of public health disaster emergency. So that's a key limitation to this section. So everything I'm about to say about local school boards and what they're doing and what's subject to review is with the caveat that at the beginning of the section, it's during a state of public health disaster emergency, which is the state of disaster emergency declared under Section 1. So the first comment I would make is that only the board of education of a school district shall have the authority to take any action, issue any order, or adopt any policy that affects the operation of any school within the school district. I note that not this section, but the repealer of the bill, the title and the repealing clause, repeals KSA 48-925B. That's the statute enacted in the 2020 special session that requires the State Board of Education to approve any executive order issued by the governor under the current 48-925 that has the effect of closing public or private school attendance centers in this state. So that statute that you enacted in the special session would be repealed, and that is because Section 5 essentially takes the place of that requirement. And rather than leaving it to the State Board of Education, all authority in this area is reserved to the local boards of education. So that's a key difference that I wanted to highlight right at the outset of Section 5. And Section 5, subsection A gives a couple examples of what it means to affect the operation of any school within the school district. So those are listed there in the statute. Section 5B then talks about how prior to taking action, issuing an order, or adopting a policy, the Board of Education has to receive and consider any relevant accepted scientific or health data. So there's our accepted scientific or health data term again, and have to make an evidence-informed decision. They have to document that scientific justification, and they have to include it in their minutes or other documentation to provide essentially for review later. Any meetings of the Board of Education when they're doing these discussions have to be open to the public. It can be done by electronic audiovisual communication or remote means when necessary for health and safety, for example. And then anyone that's aggrieved by an action taken or an order issued or a policy adopted can appeal or request a hearing, that is, by the Board of Education to contest the action, order, or policy. And the Board of Education would have to do a hearing within 72 hours of receiving that request. And the board would have the authority to extend that time under extraordinary circumstances again. And after making that decision, the board would be subject to review by a district court if the aggrieved person requests a hearing in the district court under Section 4 that we just talked about. So there's the order or action is taken. It's then you can request a hearing with the board itself to get that reviewed within 72 hours. If you're aggrieved by their decision, again, you can go to the district court and get it reviewed there within 72 hours. All waived by extraordinary circumstances, of course, but generally would be within 72 hours. The final thing in Section 5 that I'll point out is Subsection D, providing that in any school year, when there is a public health disaster emergency declared by the governor, the Board of Education of each school district is required to provide to the State Board of Education information regarding any action taken, orders issued, or policies adopted to mitigate that emergency and the impact on the operation of any school in its district. The information has to be provided to the State Board in a manner determined by the State Board. And each time they take an action, each time the Board of Education takes an action, issues an order, adopts a policy that would fall under this, they have to report that to the State Board. And then once every 2 weeks, the State Board is required to compile that information and publish a year-to-date compilation on their website so that it can be viewed by the public. And I think it'd probably be a good time to pause and see if you have any questions about this school provision in Section 5.
Mr. Thompson, I have one question in Section 5 on page 9 at line 25. It talks about affects the operation of any school within the school district. Does the bill provide any definition for within the school district? Does that mean a school that is a school of the school district, or it's just geographically located within the geographic boundary of the school district? I'm thinking private schools. Does this touch on community colleges at all? If you could, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. No, my understanding is that the school within the school district has a particular meaning in the education area. The revisor that drafted this for the bill. The schools within the school district are the schools under the authority of that school district. It would not, they obviously don't have authority to issue any sort of order or take any action that affects schools outside of their jurisdiction.
Thank you, Mr. Thompson. Committee, any questions for the reviser? Senator Pyle.
Along those, as a follow-up, if we were to proceed, maybe we need to clarify that with an amendment that it does not affect religious or private schools because they're not under that jurisdiction. So I had the same thing underlined, Madam Chair, in mind. Just questions. Thank you.
I am taking notes on where we might be looking for amendments from the committee or others outside of the committee to bring to committee regarding the bill. So thank you, Senator. Any other questions for the reviser? If not, then seeing none, Section 6, please, Mr. Thompson.
All right, very good. Thank you, Madam Chair. Jason Thompson again. Section 6, we've already discussed, but I'll briefly remind you of what is there. That's on it's KSA 48-904. It's on pages 11 and 12. This is the definition section for the Kansas Emergency Management Act, KEMA, as we keep calling it. This is the statute that creates that distinction I talked at the very beginning of Section 1 about between a disaster from foodborne, contagious, or infectious disease and a public health disaster resulting from other kinds of disease that are not foodborne and are transmitted human to human. So that's Section 6 is where that came from. We've already kind of discussed that. But it's here in KEMA, so it falls in that order in the bill. Section 7 then moves into another statute in KEMA, 48-923. It's on pages 12 through 13. And this is the statute that says the governor shall not have the power or authority to temporarily or permanently do certain things under KEMA. And I highlighted all 5 of those in the outline. Very briefly stated, I don't want to read all the language to you, is first, alter or modify the criminal code or the code of criminal procedure. Second, limit gatherings or other activities of a religious nature. Third, seize ammunition or suspend the sale of firearms or ammunition. Fourth, alter or modify election laws. Or fifth, take any action that gives preferential treatment for abortion. So those are the 5 items provided in 48-923. Some of them will look familiar to you. They're provisions that are in current law or in the law enacted in the 2020 special session that are moved here from their old places, so they apply to any action under KEMA, not just an action under, say, 48-925 or that sort of thing. It puts them in one central location, so it's applicable to a declaration under Section 1 or a declaration under 48-924 or even a local declaration, potentially. All of these are essentially things that are not powers or authorities under the Emergency Management Act. The rest, the next section is still in KEMA. It's 48-924. So I don't know if I need to pause here. There may be questions about some of those limitations, but maybe I can cover a couple more things before we discuss those. 48-924 is Section 8. That's on pages 13 through 15. And I note, just for everyone's reference, this is the section as amended by 2021 Senate Bill 14. So this is the most recent version of the statute enacted in January. The governor shall issue a proclamation declaring a state of disaster emergency upon a finding that a disaster has occurred or that occurrence or threat thereof is imminent. That's the current law language. It is preserved. The current law duties related to extension of that emergency that are conferred on the State Finance Council are given to the Joint Committee on Emergency Management, established again by Section 2 that we've already talked about. So most of the language in 48-924 is preserved. But the big change would be from Finance Council extension options when the legislature is not in session. Again, those options are given to the Joint Committee on Emergency Management instead. Then Section 9 is KSA 48-925, again, still in KEMA, and again, as amended by 2021 Senate Bill 14. This appears on pages 15 through 18 of the bill. This is the section that discusses the powers under KEMA. I think you're all familiar with this section by now. We've spent a lot of time talking about the powers that are given or not given by this section and the executive orders that the governor can issue under this section to exercise the powers conferred, in particular by subsection C of this bill or of this section. I highlight just a couple of those powers. The current power in subsection C1 that allows suspension of statutes, rules, and regs, et cetera, is modified here. It's changed here to match what's in Section 1. The power is just to modify rules and regulations and orders. That is not to suspend them, and there is no power given to suspend or modify a statute. So that is a change from current law in this bill to all the powers under 48.925, or to this power under 48.925, not just under section 1. The powers under subsections C2 through C10 remain unchanged, so those are all as they are currently. And then the power in subsection C11, the sort of broad catch-all power, is removed entirely. So it does not appear in section 1, and it does not appear in 48.925 as amended in this bill. The other restrictions in the current law, 48.925, that I was just mentioning a moment ago, are moved from this section to 48.923, section 7. Those are the stricken, that's some of the stricken material that you find on page 17. For example, not seizing ammunition or suspending firearms, or not affecting election laws. That language is now found in section 7. Removed here on page 17, but moved to section 7, 48-923. And finally, I'll note here that just like in section 1, the orders that are issued under this section have to reference the legal authority, have to have the same contents and such that are required under section 1, right? So having to cite the legal authority, cite the regulation or rule that is suspended, not suspended, I'm sorry, modified under this executive order. It has to be cited with particularity. Justifications have to be given. All of those same requirements under section 1 are placed here in 48.925 so that it applies in any kind of disaster emergency. And I note the last thing I note here in 48.925 is that subsection H that is stricken on page 18. That's about the Board of County Commissioners being able to enact less stringent provisions than executive orders under public health conditions. That's the provision moved to section 1 that we already talked about previously. So again, stricken here, but moved to another location. Then we get into a couple more KEMA issues that I can cover briefly, and then I'll take a nice long pause and see if you have any questions about the KEMA provisions, if that's okay, Madam Chair. Section 10 on pages 18 and 19 is KSA 48-933. That's the section about compensation for the use, damage, loss, or destruction of property under KEMA. The bill simply adds a reference to a declared state of public health disaster emergency under section 1 so that it covers any damages occurring under either kind of declaration, under section 1 or under 48.924. And then the bill also adds a new provision that nothing in this section authorizes compensation for intangible losses. I know there's been some discussion in the interim about whether those losses would be allowed under 48.933 or not. The bill makes explicit that intangible losses are not compensable under this section. That's not to say about anything under other law, but at least under this section, it is not compensable as a damage. Section 11 is 48-939. That's on page 19. This is the section about violations of KEMA, rules and regs of the Adjutant General under KEMA, and lawful executive orders or proclamations issued under KEMA. We add a reference here again to the kind of proclamation under section 1 so that it's covered, as well as 48.924 and local declarations. The violations remain punishable by a civil penalty only, not to exceed $2,500 per violation. And it is enforced through an action brought under Chapter 60 of our statutes by the Attorney General or the county or district attorney in the county in which the violation took place. The bill does add that nothing in this section shall prohibit an action from being brought in each county in which a violation took place, even if each action arises out of the same occurrence constituting a violation. So if somehow you committed an occurrence, you committed a violation that affected multiple counties, each of those county or district attorneys could bring an action against you and punish you with a civil penalty for that action, or seek an injunction against you as the case may be. That's provided by this section as well. And the last KEMA statute is section 12, KSA 48-949. It's on pages 19 and 20. Actually, that's not even a KEMA statute. It's in the same chapter, but it's a definition section for an act contained within this chapter, the Kansas Intrastate Emergency Mutual Aid Act. And it just amends the definition of emergency responder to include 911 dispatch centers. So it's related to the emergency powers and duties and the amendments in the bill, but it's a little separate from what we were just talking about. That's the final thing in Chapter 48. So before we move to Chapter 65, I think it's a good time to pause and see if you have any questions, Madam Chair.
Thank you, Mr. Thompson. Committee, any questions? Senator Pyle and then Senator Thompson.
On page, thank you, Madam Chair. On page 19, line 23, I know that we have used the $2,500. Can you tell me where that comes from? Where the $2,500 per violation? I mean, I assume it's already in statute, but is there any basis for that level of violation? I'm just curious, or for that level of dollar figure?
Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. Madam Chair, Senator Pyle's correct. That is current law there on page 19. And it was amended in the special session. So 48939 used to have criminal penalties, as you may recall from the prior bill. I'm going to have to pull up the bill from the session. I'll pull up the session law here real quick. And I will find what the penalty was and see if that's instructive as to how we ended up with the $2,500. Because I don't recall off the top of my head. Okay, the underlying law was that a person had committed a Class A misdemeanor and they could be punished for that. My recollection is that a Class A misdemeanor is punishable by a $2,500 fine. And so that number was probably picked up from the old Class A misdemeanor. And I'll confirm that real quick while I see if you have any other questions.
So basically we dropped the criminal charge part of it in special session, but we kept the fine level. Is that what you're saying?
Mr. Thompson.
Yes, thank you, Madam Chair. Jason Thompson again. That is my reading of, I'm trying to run the search right now while I'm talking to the committee. This is the joy of technology.
Making him look.
My reading of the statute is that, yes, we certainly did remove the criminal penalty and we retained only a civil fine. And I'm trying to get to chapter 21, KSA 216611. Thankfully, I remembered that. For a Class A misdemeanor, the fine is a sum not exceeding $2,500. So yes, this matches the fine that would have been allowed under the prior law for a Class A misdemeanor, but it has no criminal penalties.
So is Madam Chair, just follow up, is this what some of the local jurisdictions are using as a basis for setting their fines? Because I know of some local jurisdictions that are setting a fine for not wearing a mask at $2,500. And I'm just curious, is this what they're going by, what we currently have in law? And if so, maybe we need to address that issue while we're on that.
Is that maybe a question for research, if they're able to determine that? Or I don't know if that would be in law. This is why we're proposing the level of fine that we are in our jurisdiction. So I don't think, Mr. Thompson, if you have an answer, that would be great, but it's probably not something in law that would be able to be found. I'm not sure.
Madam Chair, this is Jason Thompson. I can't speak specifically to what the city or county might do, and maybe you have some conferees that could do that later on. But the statute specifically provides that this is a cap. And if you look at lines, get back to the bill here. Line 21, this is specific to a declaration of even a state of local disaster emergency, in addition to a state of disaster emergency from the state, right? So if there's any disaster declaration issued by the state or the locals under KEMA, this provision applies. And so the cap is $2,500 per violation, but there's no floor necessarily. And so there's a range that they could impose. That's my reading of the statutory authority anyway. And so, you know, if they were choosing to do a $100 fine, that's within their statutory authority, at least from my basic reading of this. And I'd be curious if they, you know, had other particular justifications for what they're doing. But you're right, I can't provide those, Madam Chair.
If we were to lower this, Jason, would that set the cap? I mean, if instead of, or raise it, whatever, 5,000 versus 1,000, whatever if we were to change this, does that set the cap then for the locals?
Mr. Thompson?
Madam Chair, my understanding is that if if the order or the violation is a violation covered by 48.939. So it's a violation because you're violating an executive order or a proclamation issued under the authority of 48.924 or Section 1 or a local declaration of emergency, the civil penalty provided in this statute is the cap, and it would apply. If the cities or counties have other statutes that they could point to that might give them authority to do that, we might need to go amend those too. But I know that this at least covers most of the situations we're talking about and does provide the cap.
Thank you. Senator Thompson.
Thank you, Madam Chair. One quick question for Mr. Thompson. On page 19, line 8, about the nothing in this section authorizes compensation for intangible losses. Let's say there's a restaurant who was put out of business or continues to be operating at lower than their normal capacity. Do they have any course of action, or does that go harken back to those sections of actions against cities or counties? Just curious if this eradicates any liability at all for the emergency, or if a business of any type has feels like they've been unjustly shut down. Do they have a course of action?
Mr. Thompson.
Thank you, Madam Chair. Senator Thompson has identified a difficult legal issue. This section specifically provides if you're claiming compensation under this section and you file a claim in the district court, it's treated like another civil action, but it's limited to the terms of this section. The amount of compensation is determined in the same way that it would be under any sort of takings or condemnation action, unless you agree with the adjutant general about what the amount should be, and then the court just orders that amount. So the provision here is meant to just specifically say, this statute does not address compensation for intangible losses. It only addresses those sort of takings and compensable damages provided by this statute. What it doesn't do is address any other civil action you might have. There are plenty of attorneys out there, I think, that are discussing this issue and whether there is a takings action or some other legal action that could be taken to seek damages from the state. But the section, the provision in line 8 that we were just pointing to on page 19 is only to deal with this particular action under this particular section. And I would caution section 4, just to not get any confusion. Under section 4, there's also a provision that says relief under that section does not include compensation. So that section is not about compensation in any way. It is about relief from the order itself or the action itself, essentially to get that overridden by a court or nullified by a court. So you would have an opportunity to get relief from the order as quickly as possible, but you would not have an opportunity to seek compensation under section 4 either. So I just wanted to clarify that.
That clears it up. Thank you. Thank you, Madam Chair.
Thank you. That brings up a question for me, though, Mr. Thompson. I'm looking back at section 4. Where in section 4 does it say you can't request compensation? Because I see on page 9 in subsection D, which is line 11, the district court shall grant the request for relief made by the aggrieved party unless, and then it goes on. So if part of the request for relief is monetary compensation, where in section 4 does it say the court can't provide monetary compensation?
Thank you, Madam Chair. Jason Thompson again. You're a good lawyer. I'll just remind the committee of that. It's the final section of that subsection, or sentence of that subsection. Relief under this section shall not include any compensation of any kind.
Perfect. Thank you. It was clear right there.
Late addition to the bill, added on to make clear that compensation is not included. So if you were the attorney filing that action for an aggrieved party, or you were pro se and you happen to request that sort of relief, the court would not be allowed to grant it under that provision.
And one final question for me regarding Section 4, at least for now. On page 19 in Section 11, we're specifically talking about violations of this section for failure to follow an order of a proper authority, that those actions shall be brought under Chapter 60. And Section 4 doesn't define whether it shall be a Chapter 60 action or a Chapter 61 action. So is that a policy decision for us, or is there some other consideration to determine whether we might want to be under Chapter 60 or Chapter 61?
Thank you, Madam Chair. Jason Thompson again. You're correct. Again, the keen eye of a lawyer, I don't believe we specified that it is a Chapter 60 action. I think that's implied and probably the intent, but I think you're right. It could be a policy choice. It could be under Chapter 61 as a small claim sort of action. In theory, we could have even made it under Chapter 65, although I think the Chapter 65 provision treats it more like a habeas action, which is also under Chapter 60. So I think you've identified the two options. It's probably 60 or 61. And because we specify it in 48.939 as a Chapter 60, we probably should specify it under Section 4, and that was just probably an oversight in our drafting. So,
okay, great, but something that we can certainly clear up with an amendment. Thank you. Committee then will move on to the next section.
All right, thank you, Madam Chair. Jason Thompson, continuing again. Now we move into the Chapter 65 statutes. Section 13 first, on pages 20 and 21, KSA 65-101. This is the statute that allows the Secretary of Health and Environment to exercise general supervision of the health of the people of the state and gives them certain powers and duties. One of them, in subsection A5, authorizes the Secretary to issue orders to take action to prevent the introduction of infectious or contagious disease into the state and to prevent the spread of infectious or contagious disease within the state. The bill creates exceptions to that authority in subsections C, D, and E. So I just highlight those without getting into too much detail here. And then review of those orders is done by the Attorney General, just as review of the orders under Section 1 by the Governor. And then a person aggrieved by an order of the Secretary of Health and Environment is allowed to request a hearing in district court under Section 4. We also picked that up. So the review procedure and the 72-hour hearing with the court procedure are picked up here in section, is that 11? No, sorry, 13, section 13. So the next section then in, the last thing I should point out in this section, I don't mention it in the outline, but I will mention it in the bill brief. The final subsection of 65-101, new subsection G, requires the Secretary to maintain a public registry on the Kansas Department of Health and Environment's website of all the orders described in Section 3 issued by a city or a city health officer, and all the orders described in 65-201 and 65-202 issued by a local health officer. These are all related to the sort of emergency declaration issued orders, and they could be issued by a city or a county. And the Secretary would have to do a registry of all of these and make them publicly available. And at least once every 2 weeks, they would compile the information received and update their public registry. That sort of mirrors the requirement placed on the State Board of Education under Section 5, where they're compiling all of the information received from the local boards and every 2 weeks updating their registry as well. So those are sort of companion provisions for the two different entities involved, or the more than two, multiple entities involved. The next section then is section 14, KSA 65-119. That's on pages 20, pages 21 and 22. This is the section about duties and powers of local health officers related to infectious or contagious disease. One of the changes here, just as background, the statute already requires the county or joint board of health or local health officer. They may prohibit public gatherings when necessary for the control of any infection, of any and all infectious or contagious disease. The bill adds an exception to that general authority to provide that no Board of Health or local health officer shall prohibit any school district or a school attendance center from operating using the powers under 65-201 or 65-202. So this specifically carves out the schools from that kind of action that they're allowed under current law. Similarly, in Section 15, KSA 65-126 on page 22, the Secretary of Health and Environment has some powers regarding quarantine in certain areas. The bill adds that this section does not apply to any school district or school within those areas during a state of public health disaster emergency declared under Section 1. So the school authority under Section 5 with the local Board of Education is preserved here, even from a Secretary of Health and Environment quarantine issue, similar to how it's carved out in Section 14 from local health officer powers. Almost done with the bill. Section 16 then moves to 65-201. It's on pages 22 and 23. This is the current provision about the Board of County Commissioners of each county acting as the County Board of Health for their county, and each county board is required to appoint a person licensed to practice medicine and surgery who shall serve as their local health officer. The statute currently provides that any order issued by the local health officer may be reviewed, amended, or revoked by the county board, but the statute in the bill would propose that that becomes mandatory. So any order issued shall be reviewed, amended, or revoked by the Board of County Commissioners. So there's one level of review there. A person aggrieved by an order can request a hearing of the board within 72 hours after that order is issued. And then if they're aggrieved by the decision of the Board of County Commissioners, they can appeal or request a hearing rather in the district court under Section 4. So orders by the local officer first go to the county board for approval and issuance, and then a person aggrieved can appeal again to that same board to have them review their action. And if they are aggrieved again, they can go to the district court, similar to what we provided for cities and already discussed before. And then the final substantive section is Section 17, KSA 65-202 on pages 23 to 25. This is the section providing all the powers and duties of the local health officer in each county. I noted in the outline that this has all the requirements for the orders issued, and that prohibits certain orders that they cannot issue. There's a lot of detail in the bill. I'll highlight that the orders that they cannot issue are orders that substantially burden or inhibit the gathering or movement of individuals or operation of any religious, civic, business, or commercial activity. The same language used in other provisions that say these can't be used unless they're justified by accepted scientific reasons. They also cannot burden or inhibit the operation of any religious gathering or activity, just like the other orders. And then one unique one that's added here is they cannot issue an order that has the effect of limiting travel between counties, except their authority under 65-129B, requiring an individual to go or remain in isolation or quarantine is not limited. So they can quarantine or isolate you under that power, but they're not allowed to limit your travel between counties. So for example, if Shawnee County wanted to limit the travel of folks from a neighboring county who don't have the same provisions regarding mask mandate, for example, they would not have the authority to do that under this section. And I think that's the issue they're trying to address, is different counties trying to maybe affect the conduct of counties around them that may have differing policies and health-related orders. And then the final section of the bill is Section 18 that provides for severability. So I'll just note that now, and I'll also note that it would take effect upon publication in the Kansas Register. So it would be the quickest effective date possible. And I think with that, I've covered the outline, and I'll be happy to answer any questions about those Chapter 65 questions or anything else.
Thank you, Mr. Thompson. I believe Senator Thompson has a different meeting to attend, so we'll entertain his question now. Senator Thompson.
Thank you, Madam Chair, and thank you for your comprehensive look at this, Mr. Thompson. One quick question, and this is kind of a general question. The original problem with all of the KEMA statutes is that it was originally designed to address natural disasters, animal health disasters, things of this nature. Is there any language in this bill that, because we're still going to have those types of disasters, that just specifically sets this aside for a statewide emergency? Because there's only been one other statewide emergency in the entire history of the state, and that was an ice storm. It lasted for like 15 days. This is unique because it's gone for almost a year, and it's been statewide. Does this bill address that, set this aside as something special? Maybe I'm not making any sense here, but do you understand what I'm getting at?
Sure. Mr. Thompson, if you can answer.
Thank you, Madam Chair. Jason Thompson again. I think I understand what Senator Thompson was going at. And just as a big picture, and I tried to lay this out back at the beginning, an hour ago. So thanks for bearing with me for all of that. The idea here is that 48-924 and the powers under 48-925, the current KEMA statutes for declarations of emergency, would be modified a little bit, but it would otherwise be available for all the kinds of natural disasters we've had in the past. That Section 1 and these other health-related issues are sort of carved out as a public health disaster emergency that are treated differently. There are provisions that talk about how if an order affects more than one county, that triggers certain things that don't apply if it only affects one county. There are provisions that prohibit certain things from being statewide, or allow an opt-out if things affect more than one county, for example. So I believe the intent is there, and the bill has a lot of language that attempts to clarify one certain kind of disaster can be declared by the governor that relates to certain diseases and public health issues, and all other kinds of disasters can be declared, by the governor under this other statute. It doesn't affect, I should note, I guess, the local declarations of disaster emergency, right? They still have that power under KEMA to deal with a specifically local disaster. And I guess the last thing I would say, just to not go too far on anything, is that the governor could still, I kind of lost my train of thought there. So local disaster, so a disaster, even a public health emergency that only affects one county, right? The local health officials have authority to deal with that through quarantine and isolation and other restrictions within an area, right? That's one of the statutes in the bill. So if you have just a disease, a typical infectious or contagious disease or some sort of outbreak or epidemic that's confined to the jurisdiction of a county health officer, that's dealt with in current law and preserved, essentially. Maybe with some restrictions about the orders they can issue or whatnot, but they're allowed to manage that. And if it goes beyond one county, that's where it gets to the Secretary of Health and Environment, and they're allowed to manage that, maybe with some restrictions, but still allowed to manage that infectious or contagious disease. And if it then goes beyond that to the governor's level, that's when Section 1 and some of these broader emergency declarations kick in. So I may have said too much or too little, but hopefully that's responsive.
Oh, I think that covered it. My concern was that, say you had a tornado ripped across a couple counties, and is there a geographical restriction on this before all of this craziness kicks in? But I think you answered my question. I just want to make sure that was addressed in the bill so that, this couldn't be implemented because a tornado was on the ground for 100 miles and crossed 2 or 3 counties. I just wanted to make sure that we were limiting the scope of these emergency declarations to something that is statewide and affects all Kansans or a very large majority of the state. And I think Mr. Thompson explained that well.
Thank you. Senator Pyle.
Thank you, Madam Chair. Jason, in light of the, well, first of all, I have a question. I'm curious where this bill, who drafted it, where it came from. If someone can answer that question, Madam Chair, was it introduced in this committee or requested in this committee or in the House? Where?
Thank you, Senator Pyle. It was introduced in Senate, Fed, and State as an exempt committee so that we would have the time we needed to work on it. You understand we're under a short deadline. We have March 31st, 2021 approaching, and when a lot of the provisions in law that we enacted in Senate Bill 14 expire. So that's why this is kind of a priority this week.
Well, and Madam Chair, I'm just curious as to, in that committee, someone requested this language. Did that come from an agency? Did that come from a legislator? Do we know? Did it come from leadership? I mean, who drafted the bill? That's what I'm curious.
Sure, I think Senator Wilborn can speak to that.
Thank you, Madam Chair. It's a good question. It was an amalgamation of leadership. It was an amalgamation of looking at the bill we passed last year, oversights that were made last year, questions that were made last year. And if I don't mind mentioning names, special attention was given to by our revisor's office, Jason Thompson, and also by Eric Rucker and by Darren Beckman. And the collaboration of all of that came together.
Thank you. With that, Madam Chair, I'd like to ask, in light of the announcements that were made this week by the Attorney General and leadership of both chambers for a concurrent resolution to put on a ballot before the people for legislative oversight of rules and regs, if we look at page 20, line 39, where it says the Secretary of Health and Environment may adopt rules and regulations. Jason, if that constitutional proposal were to pass, would this be in conflict? I mean, I'm just asking.
Mr. Thompson.
Thank you, Madam Chair. Jason Thompson, again, with the revisor's office. I'll caveat with, I have not seen that language. I am not the drafter of that language, but my understanding of the constitutional amendment proposal is that it just allows the legislature to review and reject rules and regulations in a way that they cannot do now. So it would not necessarily affect the authority to issue rules and regulations. It would be after the regulations are issued that they could be, nullified by the legislature.
And so my understanding then, if the legislature is not in session under that constitutional proposal, the legislature would not be able to act under an emergency. Should the Secretary of Health make rules and regs, the legislature would have to wait until they're convened. Is that correct assessment?
Mr. Thompson.
Thank you, Madam Chair. And Jason Thompson again. Typically in an emergency, they're not issuing rules and regulations. If they did, they would be temporary rules and regulations, and there's a whole procedure provided for that in the Rules and Regulations Filing Act. Typically, it would be an order or a policy or something that would be reviewed under this bill that we'd be talking about if the legislature was not in session. But I guess my answer is if they do issue temporary rules and regulations, there is a procedure set up for that. In the Rules and Regulations Filing Act, there is some oversight. There's still review by the Attorney General. There are procedures to handle that in current law. Whether they're adequate is a different policy question for you, of course. But.
Thank you. I do have another question on this other section where we deal with in section 14 and 15, and we're dealing with the local health officers shall, except no board of health or local health officers shall prohibit any school district. I'm curious, the way that's written, who could prohibit the school district or school attendance center from operating? We're only prohibiting the local health officer or the board of health. So is that a limited prohibition, or does that need to be brought? I mean, I'm just asking by the reading of it in both places. It's on page 22, be lines 13 through 16 and lines 30 through 32. It seems to be a very limited prohibition to just the local health officer and the board of health. Am I correct in that assessment, or would this carry over to where the governor could not prohibit the schools from operating?
Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. The senator is correct that these two provisions are limited, but they have to be read in concert with Section 5. So when my education advisor helped me with this draft, the three pieces I was given from them were Section 5 saying, well, and the repeal of 48925B that deals with the State Board of Education in this matter, right? So repeal that statute, enact Section 5 that gives all power to the local Board of Education of a school district, and then also amend these two sections that we're talking about here, Section 14 and 15, that give either the secretary some power that could impact closure of a school, and local health officers some power to impact the closure of a school. So we specifically carve them out of those powers, and we give that power to the local Board of Education, specifically in Section 5. So read in tandem, it should preserve all power to the local board.
Thank you very much. Thank you, ma'am.
Senator Baumgartner.
Thank you very much, Madam Chair. So I'll just kind of dovetail that with regard to schools, because we know that there is that carve out for schools. But when I'm looking at page 22, lines 30 through 32, it doesn't apply to any school district or school within any such area. And I think part of that clarification when we're talking about or school within that area, because there was the question about that on page 9 as well, we probably ought to have something like a district attendance center when we're talking about that actual school. But again, it leads to the concern that I have, and that is we are not anywhere in this document addressing community colleges, technical colleges, or regents institutions, or private colleges and universities. I have begun work with the reviser, Madam Chair, because I do believe that we need an acknowledgement of those attendance areas for higher ed, and so I will be bringing that. We've already started conversation with Mr. Thompson, so I will be bringing that with regard to higher ed. Another question that I have, when we're looking at page, I guess, 20 and 21 with regard to the secretary, just basically those rules and regulations that the secretary can impose. I guess this is a question for Mr. Thompson, because we know that in our current pandemic, the secretary came out with these are the guidelines, and I believe they're just guidelines, and yet we know within counties they're addressing them as this is the rule, and that is the distribution of the vaccines. And we know in Wyandotte County, at the beginning of the rollout of the vaccines, and the secretary had indicated that those were only to go to, that first phase was only to go to healthcare workers. And we know that we had a psychiatrist in Wyandotte County that signed up 30 different individuals. They were friends. One of the individuals was actually a person that had done yard work for the psychiatrist, but 30 different individuals went in and jumped the line, if you will, to get that vaccination. And so I guess my question is, what action, is there any action built in this that would address folks that are in violation, similar to what occurred with the vaccine?
Mr. Thompson, if you can answer that, and maybe that goes to the section where we were talking about the $2,500 maximum civil penalty for violation of an order. I don't know if that would be where this particular concern raised by the senator would be addressed, but if you could answer the question, that would be helpful. Thank you.
Sure. Thank you, Madam Chair. Jason Thompson again. I'm not sure whether that provision would apply. I don't know under what authority that order, directive, I'm not even sure under what authority that action was taken, what it was called. But if it were somehow under that statute, it would be up to the Attorney General, the county district attorney, to bring that action and seek that civil penalty for any person that caused the violation. So that's an option. I don't know if it's available in this case or not. I just don't know enough. And I don't know depending on the authority used by the Secretary of Health and Environment to declare how things are going to run, I don't know whether it would fall under KEMA and or the Chapter 65 statutes that we're dealing with here, or if that's handled separately. The vaccine distribution was a complicated issue that I'm not competent to answer.
Recognized as representative from Derby.
Thank you, Senator.
Well, Madam Chair, I mean, when we are talking about the type of disaster that we are speaking to, a part of that is oftentimes there will be a remedy. When we look at other situations, before we had the polio vaccine and things like that, a part of that process is we are looking for the remedy of the disaster, of the biological disaster. But I don't see that we're necessarily addressing this with regard to anything other than orders of quarantine. And I'm just wondering if there is a place for that and where that place might be. I guess another question that I do have is, Jason, if you can clarify for us, when we have a either a state disaster or a national disaster, federal funding comes in to the state as a part of that declaration. And we don't necessarily know what that funding would be. But I'm not saying, is there anything in what we're looking at right now with Senate Bill 273 that provides for oversight of the distribution of federal funding coming in and accountability for the funding that is distributed? Thank you, Madam Chair.
Mr. Thompson?
Thank you, Madam Chair. Jason Thompson again. No, there's nothing in the bill that specifically addresses distribution of funds. I recall just from our special session bill with the appropriations provisions that were at the beginning of that bill, that there may be appropriations issues that already handle this. And so again, I guess I'll just give the caveat that I'm not the competent person to answer the appropriations issue, but I can tell you there's nothing in this bill like there was in the special session bill about directing funds or requiring oversight. That's all handled on the appropriation side and would be something else we would need to do.
Madam Chair, I will simply say if we just take a look back at the hearing that we had yesterday, one of the things that we learned from just the judiciary testimony was there was a small amount of funds that were distributed to the judiciary for PP or for the personal protection. And we were told that all of those funds had been drawn down and were used. And the example was a particular courtroom where only two of the actual room or courthouse and only two of the actual courtrooms were safe or appropriate for hearings. So it does seem to me that at some point we need to, when we're talking about response to an emergency that would be declared a disaster, and that is exactly what Senate Bill number 273 is. That declaration of disaster does bring about federal assistance. And if we are not going to have oversight so that we can continue, and why do I feel this is important? Because all of Section 4, the remedy that's been created through Senate Bill 273 is go to the court. Go to the court. And we give a person that's aggrieved, go to the district court. A person that's been aggrieved, go to the district court. I mean, step by step. So if we're not going to make it that the district court is even going to be functioning, that whole Section 4 is just blue sky as an actual appeal process beyond county commission or school boards. So at some point, we can't have a part of the remedy for folks that are aggrieved be something that by fiat, by executive order of a governor, to shut down the courts or not having funds going so that the courts can be operational, I think that we need to make sure that we go for full circle with this. Thank you, Madam Chair.
Thank you, Senator. Those are valid concerns and issues that we need to be looking at. Part of the remedy provided by Section 4 is if you're not provided relief at the city or county or school board level, that you go to the district court. Well, for some time, and I think we did hear from the Judiciary branch yesterday that courts have been operational, but not, I don't believe the whole time, once the state of emergency declaration began last March. So what would an aggrieved person do if their final line of review were the district courts and the courts were closed? It's a question that we need to look at, and oftentimes we were hearing the courts are operating through audiovisual technology, so they're not in the same room, you're off-site, you're remote, but something to consider, as well as oversight and accountability of federal funds that come in. I don't know if that's something that when those funds come in, whether the State Finance Council would have an opportunity to review the expenditures or not. If so, we need to clarify that. If not, we need to put something in place. So we'll probably be looking at possibly amendment to the bill if someone brings one to the committee. Do we have other? Yes, Senator Baumgartner.
Thank you, Madam Chair. Well, it just does drive to me on page 9, line 19 and 20. Relief under this section shall not include any compensation of any kind. And so, quite frankly, if the aggrieved individual is unable to get any relief with the county commissioners or the city or the Secretary of Health, and our solution for them is to go to the district court, but the district court is not operational, there is no solution. And so they are stalemated. And I do think of the hearings that we had during when we were back here for the emergency session, and that was the frustration for folks. Businesses were closed, all kinds of things were closed, and they had no recourse. And so we have to make sure there is a recourse, which based on what we are laying out in new Section 4, if those district courts are not available as that recourse, then Section 4, in essence, would need to be removed. Thank you, Madam Chair.
Thank you, Senator. It wouldn't be obviously ideal if the district courts were closed, for sure. I would be interested in hearing the committee's thoughts on, I understand the intent of Section 4, and I don't recall from our hearing yesterday how long the district courts were actually closed and not operating at all. Even on a remote basis, the judge in one location, the party in another, that they were still able to conduct business. It's not a perfect system in Section 4, granted, it's not ideal. Open to other suggestions. I want to make aggrieved persons provided as much relief as possible, and if we can design it better, let's do that. I think that's the work of this committee, to do that. So I would entertain discussion on that topic as well. With that, other questions or comments? Yes, Senator Gossage.
Thank you, Madam Chair. There has been some concern that we've heard from our constituents regarding that the health director in counties has too much authority. They felt like that if they're issuing an order, that it becomes a mandate, and that the city county commission or whomever feels that they have to bow down to whatever was ordered of them without realizing that actually they could be making the decision. Now, oftentimes those are going to be the same decision. So I'm looking at an amendment that would change order to responsibility, something of that nature, where they would give a suggestion from them as opposed to an order.
Thank you, Senator. Thank you for raising that concern. I hear the same issues and concerns from constituents as well. When you call it an order, it has a different effect under law, if you will, than a recommendation or a suggestion, or if you call it a mandate, something different. So we'll be looking forward to then that amendment to discuss that.
And I think the word that we have settled on is exactly what you said, which is recommendation.
Okay, great, thank you. With that committee, we do have a conferee for the committee if we don't right now have any further questions for the reviser, and I don't see any. So with that, we have, do we have any proponent conferees in the committee meeting room or on WebEx today? Seeing none then, committee, we will move to neutral conferee, and we have Jay Hall from the Kansas Association of Counties, looks like appearing by WebEx. Mr. Hall, please introduce yourself and welcome to committee.
Thank you, Madam Chairwoman. This is Jay Hall from the Kansas Association of Counties. Thank you for hearing my testimony. I'm sure probably a lot of you have not had a chance to read my testimony because I got this in pretty late last night, but I do appreciate being able to speak to the community today. And our concern as KAC centers on the issue that you were just talking about with local health officers. And it really, I know a lot of the focus right now is on COVID-19 and some of the response to COVID-19. But we also have to remember that the Emergency Management Act and the powers of local health officers are not restricted just to what's going on right now with COVID. They need some of these powers to carry out their normal duties. And a good example I would give is probably if there were to be, for example, a measles outbreak that's much more localized, the local health officer needs to be able to pass on certain orders and things like that in order to control the spread of something like measles or some of the other acute infectious or contagious or communicable diseases. And so that's really our concern, is that some of the language in sections 14, 15, and 17 limits those powers. And while that may serve the desired purpose in the situation we're currently in with COVID-19, that may also handicap those same individuals when dealing with a very localized issue. And so that's our concern with this bill, and something that I wanted to raise to the committee here today. And I'd be happy to answer questions if there are any from the committee on this topic or on any other topic related to KEMA and how it affects counties.
Thank you, Mr. Hall. Do we have any other neutral conferees in the committee meeting room or on WebEx? Seeing and hearing none then, committee, any questions for Mr. Hall? Yes, Senator Gossage.
Thank you, Madam Chair, and thank you for being with us virtually. My question is, and I did have an opportunity to read through your testimony, so thank you so much for sending that to us. You were referring to a small section about school boards, right, and school districts?
Yes, ma'am.
Okay. How would you like to see that changed, or what is your thinking on that, if I may ask?
I think that our county health officers do need to have the authority to maybe in isolated situations close a school. If, for example, you have a measles outbreak that's isolated to, for example, a kindergarten classroom in a specific school. You may need to have that class closed down for a week or two in order to address that and make sure that that doesn't spread throughout the rest of the school or to other children within that school. That would probably be one of the best solutions to a situation like that. But simply saying that the local health officer did not have the ability to address that situation leaves them a little bit hamstrung in their responsibilities of investigating and also preventing the spread of contagious diseases.
And if I may, Madam Chair, Just as a follow-up, I'm a former teacher, and I can recall a time when, there was an outbreak of lice in a classroom, and the principal made the decision that we're going to close, this classroom, we're going to take these measures, or something to that degree, but often after consulting, with the health director. So that would already be done, correct? Isn't that something that could be done now?
That's certainly something that could be done now, and I would hope that the schools would be working with the local health officer if they had those sorts of issues coming up, so that the coordination could be happening, so that because we also have to look at obviously if there is an outbreak, there is also the chance that a brother or a sister of one of the children in that particular classroom is also in another classroom that may be subject to that same outbreak. And so just the necessity of trying to control that type of spread and isolate it so that you don't have that situation running rampant. That's really our concern at KAC, is just to make sure that the local health officers have the necessary tools in their toolbox to safely address those situations with as little disruption as possible.
Thank you.
Thank you. Other questions for Mr. Hall? Seeing none then, thank you, Mr. Hall, for appearing today in committee and for your testimony, and for being patient while we got through the bill. It's lengthy, and we had a lot of good questions and discussion as we went through it with the reviser, so thank you for waiting patiently while we did that. Thank you.
Thank you.
Thank you. Committee, are there any, excuse me, I will ask in the committee meeting room or on WebEx, do we have any opponent conferees? Seeing and hearing none. Committee, we have worked long and hard to get through the bill today with the reviser, and we heard from a conferee. I believe we have other conferees who have signed up to provide testimony tomorrow. So we will continue the hearing on Senate Bill 273 tomorrow, and I think Senator Wilborn had a comment to make before we close. Did any other senators have a comment before we, and I don't mean close, but I mean adjourn. Thank you, Senator Wilborn.
Thank you, Madam Chairman. Going back to the response or the question that Senator Pyle asked, I failed to mention a very important component. We had business, industry, the medical community, and the Attorney General in an open meeting, all giving their input. Some litigators that have been litigating some of the cases that had become before because of the pandemic. So it was not created in a vacuum. And I failed to mention that, Senator Pyle, but there was a business, industry, medical, Attorney General, a meeting, number of people there.
Thank you, Senator. Senator Pyle.
Thank you for that information. I failed to catch when that was posted or put out for public view. Was that meeting a closed meeting?
That was not a closed meeting. It was open invitation, and I could, after the meeting, get you the minutes and the outline of it, but that was an important component that I failed to mention in your question.
Thank you.
Thank you for clearing that up, Senator. Yes, Senator Baumgartner.
Thank you, Madam Chair. We've been told that we were to be ready to work through lunch today and work through lunch tomorrow. We needed to have amendments ready, and that the direction was that we were to work to get this bill pushed out tomorrow. So if we're having hearing tomorrow with folks signed up to testify, I guess I'm wondering, when is it that you're planning tomorrow that we're going to work the bill?
Thank you, Senator. Further clarification, I'm glad that we clarified the questions that we have in committee. It is still the plan to work Senate Bill 273 tomorrow, so please get with the reviser today, committee, if you have amendments to bring. I believe the reviser, Jason Thompson, is kind of heading up where to direct your particular amendment. If it's a schools issue amendment, Mr. Thompson can direct it to the reviser who's working on more of the school amendments. The health issues might be a different reviser. So please, committee, get those amendments to the reviser as soon as you can. The intent is for tomorrow to limit testimony to the first 30 minutes of our meeting time tomorrow, and then we will move into working the bill and working on any amendments and discussion and debate. And the plan is to have a vote on it tomorrow in committee. If we need additional time, we are scheduled to meet on Friday as well. But I wanted to have committee have time to have heard the bill from the reviser and its details today, and then to have the opportunity to look at some amendments. I would welcome an amendment if someone is looking at the schools issue regarding, do we need to clarify within the school district? We've talked about the school boards can't affect the operation of schools within their school district, but does the bill specifically mention private schools in there as well? So we might need an amendment to that effect as well. Does that clear it up? And is that, I think that will allow us to meet the deadline to get this out of committee by Friday at the latest. Tomorrow is the goal, but yes, Senator Corson.
Madam Chair, thank you. Is your plan on the speedy trial bill then that we'll work that on Friday? Is that your anticipation?
Senator Corson, thank you for clearing that up as well. Yes, I would anticipate that Friday we will be working speedy trial. That would be Senate Bill 57. So amendments would need to be ready by then as well. Do we have any other questions of the committee kind of about the rest of our week? I would intend to work if it would be, again, I announced we would work through the lunch hour. We've kind of done that today, that we do that tomorrow as well. We do have 1:30 committees to get to tomorrow, so I wouldn't anticipate working past 1 p.m. tomorrow, but let's do the work on the bill tomorrow, and we'll see where we are at 1 o'clock, whether we're able to pass it out of committee or we will leave that for Friday committee. So with that, thank you all for your attention and your work today. We are adjourned.